Thank you, Count Corley. I move to introduce the Informal Adoptions Regularisation Bill 2019. Adoption was first introduced to Ireland and regulated by the Adoption Act in 1952. There was no lawful adoption in Ireland before 1952, and for a period after 1952 there was a widespread practice of informal adoption. Sometimes this took place within the wider family, and sometimes through the aegis of church or other voluntary agencies like St Patrick's Guild. In May last 2018, 126 cases of illegal registrations were finally confirmed by TUSLA following an analysis of files from St Patrick's Guild. These cases had their adoptive parents incorrectly registered as their birth parents on their birth certificates between 1946 and 1969. Instead of applying under the Act and registering with the Adoption Authority, infant children were simply transferred directly into the hands of their new adopting parents. The information provided to register the births was false, and the children were, as a result, given false birth certificates as the children of the adopting couple. This is where the illegal registration occurred. This generation of children are now adults in their 40s, 50s, 60s, even 70s. They are without the benefit of a valid adoption order, and their status within their families is legally uncertain. There are an unknown number of informal adoption arrangements. Some may not be documented at all, but the people so far identified are in limbo. They're in no man's land as regard to certainty on their status. A scoping exercise, we're told, is underway, and we know already that a further 748 cases are of concern, all from St Patrick's Adoption Guild, one adoption society out of very many. To date, the Minister has not indicated what legislative action will be taken to address these illegal registrations and provide legal certainties to those affected. I think it's important to note that a birth certificate is not an identity document, nor does a birth certificate amount to proof admissible in court of the family relationship that it asserts. But the bill seeks to address this uncertain status. It defines the process of informal adoption as involving placing a child into the care of a married couple, neither of whom were parents of the child concerned, with a view to the child being held out and considered for all purposes to be the child of the couple, born to them in wedlock, or to be their adopted child, without any regard to the need for an adoption order, and the furnishing of information in connection with registering the child's birth, purporting to show the couple to be the natural parents of the child. Where documentation is available and an individual desires a valid adoption, a person who is formally adopted can apply to the Circuit Court under this legislation for a declaration of adoption. If satisfied with the evidence presented, the Court may make a declaration that the applicant is deemed to have been validly adopted on a particular date. The Register of Births will then cancel the false birth certificate, while the Adoption Authority will issue a valid adoption certificate. The second remedy deals with individuals who may have been told and had believed that they were indeed the natural children of those who reared them as their parents. They had no reason to believe that they were adopted, regularly or irregularly, and there may be no surviving records to enable them to trace the original parties to this informal arrangement. The bill would change the rules of evidence to protect those who wish to preserve what they had considered to be the status quo. First, it incorporates into civil law what is since 1992 a rule applied in criminal law. A document purporting to be a birth certificate is evidence admissible in court of the family relationship that it indicates. Evidence contradicting a birth certificate proffered in court will be inadmissible where the person whose birth certificate it is has consistently been treated with regards to the rights and duties of parents and children in relation to each other as the child of the persons named on the certificate as his or her parents. This new rule would not apply where someone fraudulently procured their own birth certificate. And the purpose of this is to allow people who've now been thrown into no man's land to have this very irregular situation addressed. And can I also say as well that what the Minister is offering is social workers to people in their 40s, 50s, 60s, 70s to pursue the issue. Actually, people don't need social workers. What they need is a fairly simple court process to regularise their status. It's the children of today who are homeless who need the attention and support of social workers.